The message Judge T.S. Ellis III gives lawyers in his court is clear: keep questions on point, move briskly and show some respect. Alexandria, Virginia. Judge T.S. Ellis III had dismissed the jury for the day, but he was not quite finished opining about what he saw as irrelevant and repetitive questioning of a witness in the financial fraud trial of Paul Manafort. Standing up so as to loom even larger over the courtroom, he angrily confronted Greg D. Andres, the lead prosecutor. "Look at me," the judge demanded, slamming his hand on the wooden ledge. "When you look down, it's as if to say, you know, that's BS, I don't want to listen to any more from you. Don't look down. Don't roll your eyes," he told Mr. Andres, and so for the second time that afternoon, the prosecutor had to try to convince the judge that he only looked down because otherwise, he said, he would be yelled at again by the court for his facial expression when, "I'm not doing anything wrong, but trying my case." Judge Ellis, 78, is the formidable ringmaster of the greatest show in the United States District Court in Alexandria, Virginia, demanding both precise questioning and a breakneck pace in the trial of Mr. Manafort, President Trump's former campaign chairman. He has routinely broken in on questioning, limited admission of evidence and exhorted lawyers to expedite, all the while entertaining spectators with humorous asides about his age, his wife, his Navy past, his lack of an email address, the jury's lunch menu, split infinitives and the noise produced by a machine intended to keep bench conferences from being overheard, like the sound of waves crashing. An appointee of President Ronald Reagan, he has pushed the customary limits of judicial intervention so far that Mr. Andres at one point seemed to suggest the prosecution had grounds to appeal. After the prosecutor complained Monday about the number of times "Your Honor stops us and asks us to move on," the judge declared that he would stand by the record. "I will stand by the record, as well." Mr. Andres responded, "Then you will lose." Judge Ellis said, "Mr. Manafort's lawyers have stayed out of firing range so far, but their turn could come when the defense starts putting on its own witnesses." Judge Ellis has a reputation for being harder on the defense than on the prosecution. To his admirers, Judge Ellis's bluntness and impatience are indicative of a razor-sharp mind. He has degrees from Princeton, Harvard and Oxford. His questions to the Manafort witnesses have been very much to the point. The answers have usually been revealing. And even on days when he has juggled sentencings in other cases, he has paid careful attention to every witness who has taken the stand in the Manafort trial. Hardly a minute seems wasted in his courtroom. You would really catch hell if the court was sitting there and the jury was sitting there and there wasn't anybody sitting on the stand. Richard Serafini, a South Florida lawyer, recalled of the health care fraud case he tried before Judge Ellis roughly 2 decades ago. "He probably had more people waiting in the witness room in that case than any other case I tried. But some lawyers question whether he is so controlling that he unfairly restricts how both defenders and prosecutors can operate. He loves the law," some lawyers who have been before him say sardonically, "almost as much as he loves himself." "He can be very dominating," said Jim Brosnahan, a California trial lawyer who defended John Walker Lind in the American Taliban case before Judge Ellis. The interesting question is it aimed fairly at both sides, or is it particularly at one side? The judge's penance has been to have some lawyers appeal his rulings on the basis of his courtroom behavior, although it is unclear whether any of those have been successful. One defendant, appealing a guilty verdict to the Fourth Circuit Court of Appeals, argued that Judge Ellis had interfered with his defense by repeatedly interrupting his counsel's questions and closing argument and, essentially taking on the role of a prosecutor. The appeals court ultimately rejected that challenge last year, noting that Judge Ellis had interrupted the prosecution virtually the same number of times and ultimately allowed the defense to finish the final argument. Whatever criticism he has faced does not seem to have fazed Judge Ellis at all in his conduct of Mr. Manafort's trial, the first to consider charges stemming from the investigation led by Robert S. Mueller III, the special counsel. "I am a Caesar in my own Rome," he said at one point, discussing why he refused to allow defendants to plead no contest instead of guilty. "It's a pretty small Rome," he added. Some lawyers who have been in his courtroom say it's better to allow him to have the last word rather than engage in what are essentially contests over who has more intellectual firepower. Away from the courthouse, lawyers and former clerks said, there is a softer side to the judge not always visible from the bench. The first judge to preside over a naturalization ceremony in Arlington Cemetery, Judge Ellis is known for growing emotional every time he administers the oath of citizenship. To the jurors, the judge could not be more solicitous, joking about the plain lunch menu you won't find baked Alaska. At least the meal is free, he told the jurors on opening day, saying he hoped no one had a fleeting urge to slit their wrists because they had been unfortunate enough to be picked from the jury pool. He has clearly reveled in his captive audience. My hearing is not what it once was, he said last week, pausing for a beat with comic effect. Nothing is what it once was. Born in Bogotá, Colombia, he took the opportunity during a sentencing to display his fluency in Spanish, questioning the defendant himself while an interpreter stood by. Even if the spectators had come only for the Manafort case, he said, he was glad they got a chance to see the criminal justice system at work. He has weighed in on a variety of issues outside the courtroom, criticizing conditions at a Virginia prison and questioning whether sentencing laws are too harsh.